Now like to call our last speaker of the day, Bemisola Osadua, who is a legal and policy specialist in digital governance and international trade. She works in regulatory framework that enable inclusive participation in the digital economy. Thank you for being here today.
And thanks for the amazing presentation that we have had before now. It's so interesting listening to the presentation from the last speaker, and that gives an idea of how enriching the conference has been. First, to start with, I want to say happy MSME Day in advance, which is technically tomorrow, and it's just been so amazing to see that all of this connection in the advent of the change that is happening in the global ecosystem today, that we are putting so much effort to ensuring that we're able to make the connection amongst experts across various sectors to make a difference for MSMEs, because in any economy, in any country, MSMEs are the drivers. So without much ado, I would start my presentation today. So just pardon me because I'm using two screens. So I have my presentation here, so I can just control it from here. So yes, again, good evening, everyone, and thank you for the introduction, Ritika. Thank you, Santosh, for the invitation, and thanks to all of the amazing panelists that have spoken before now. So I'm going to begin with what I'll call a defining paradox in global trade. So we are living in an era where a small business in Lagos, micro enterprise in Chennai, or a startup founder in Nairobi can, in theory, reach a customer in London, São Paulo, or Seoul before the close of a business day. And the digital economy has done something extraordinary. It has democratized market access in a way that no trade agreement in history have been able to fully achieve that. And for MSMEs, that should be the most exciting development of the last 2 decades. However, there is the tension that none of us in this space can afford to ignore. And the same digital economy that has opened these doors have also erected a new generation of barriers, invisible, complex in many cases, and deliberately asymmetric. Not tariff walls, not custom checkpoints, instead, a fragmented, fast evolving, and often contradictory regulatory architecture that was not designed with the small business owners in mind, like we have in our audience today. And when a multinational corporation enters a new digital market, it deploys a legal team. It has compliance officers. I mean, they even recruit some of us lawyers as the compliance officers, government affairs advisor, and regional counsel. That's for the multinationals. But an MSME does not have those resources. And yet it is being asked to navigate the same labyrinth as the big multinationals. And this is what this session is going to be about today, not the theory of digital trade law. I'm not going to be sharing the theory of digital trade law. I will save that for the academic conferences. What I want to give you today is a practitioner's map of where the real risks are, and more importantly, the concrete legal strategies that can neutralize them before they become business-ending liabilities for MSMEs. My work sits at the intersection of digital trade regulation, e-commerce governance, and AI policy in emerging market, with a particular focus on the African continental free trade area. And I've advised governments, international institutions, and businesses on exactly this kind of cross-border regulatory challenges we're going to unpack together in the next few minutes. So by background, I'm an international corporate and commercial lawyer, international trade and investment advisor. I'm also currently a doctoral candidate at the University of Geneva, and currently a doctoral fellow at the Beckman-Klein Center for Internet and Society at the Harvard Law School here in Cambridge, Massachusetts. So let's get into it. So what I'm going to be doing at first is to be mapping the regulatory minefield. So I'm going to be talking about the regulatory minefield or MSMEs. And before I give you a solution, I need to make sure we share the same even common picture of this problem, because in my experience, most MSMEs significantly underestimate the complexity of the regulatory environment they are entering when they go digital or they go across border. There are three converging layers of risks that every MSME is expanding internationally. That every MSME who is expanding internationally must sort of pay attention to. And these areas of risk, which I'm going to be touching on, are the e-commerce framework, the intellectual property, and also the cross-border data governance. So I'm going to be starting with the first, which is the e-commerce framework layer. There is no single global rulebook for e-commerce. What exists today, as we have it, is a combination of parchment of national and regional regimes. Like probably ahead of this session, most of our audience who are MSMEs might have been thinking, oh, this session is going to give me that map, that roadmap to navigate all the regulations, or sort of give me an idea of having just one layer of regulation and learning about how I'm going to navigate every market. And that's why I'm communicating it from the outset that there is no single rule book on e-commerce. What exists is a parchment of national, regional regimes that vary not just in their content, but in their foundational philosophy. For example, the European Union Digital Service Act imposes obligation on platforms and sellers operating in EU markets that are amongst the most demanding in the world, covering everything from content moderation, algorithm, transparency to consumer redress mechanism. And also we have the Indian e-commerce regulation, which is currently in a state of active revision, which imposes specific requirements around foreign direct investment, marketplace conduct, and sellers' disclosure that can fundamentally affect how a business structures its operation. And we have the AFTA protocol, which is the sort of regional focus of my work, which is still being operationalized, especially it's important for us to know this, especially for the MSMEs in our audience who are looking to get into the African market or to expand to the African market. This protocol represents an ambitious attempt to create a harmonized continental framework for African digital economy, but its implementation is uneven and its interaction with domestic laws in individual member states remains a lived question, which I'm still asking even in my research work. And what this means practically is that an MSME operating across just 3 or 4 markets may be subject to 3 or 4 entirely different regimes governing the same transaction. The cost of getting that wrong is not just a regulatory fine. Getting it wrong is not just about, oh, my business probably will be fined for some regulatory breach. No, it can mean platform delisting for such MSME. It can mean contract invalidation or reputational damage that is very difficult or almost impossible to sort of recover from. So the second layer, which I'll be touching on, which is the intellectual property. This is the area where I see most MSMEs make the most costly and most avoidable mistake in my experience as a researcher and even as a practitioner, as a e-commerce trade and advisor. The core misunderstanding is this. As an MSME, your intellectual property protection does not travel with your product. No, the fact that you took your product to another jurisdiction and because you registered it, say in, let's say in India, doesn't mean because you move it to Africa that that's the intellectual property, which you have probably done some registration in India, would travel with it to maybe another country or even within Asia. The trademark you register in your own country gives you no automatic protection in your target market. The copyright that subsits in your creative work under your domestic law may not be enforceable in a jurisdiction with weaker IP infrastructure or different accession status to international convention. The specific vulnerabilities that I encounter most frequently are trademarking squatting. So trademarking squatting is where bad actors register a foreign brand name in a new market before even the brand arrives itself. And what to give more context to that, say you have your business, or your particular trade say in Sri Lanka, and then you are going into another market. You probably didn't even envisage you were going into another market, but because of particular way your trade is sort of standing out in, say, in Sri Lanka, some bad actors can probably envisage that you are likely going to be maybe expanding to the markets in Indonesia in future. And for that reason, they will go ahead, they would register that trademark there. So that's what trademark squatting is. And these are some of the things that brands, MSMEs, do not envisage. And another vulnerability is the enforcement gap in jurisdiction, where the legal infrastructure and IP protection is still developing. For digital products in particular, the risk of unauthorized reproduction, adaptation, or resale in markets with weak enforcement mechanism is a genuine commercial threat. So the third layer I will be touching on quickly, and in my view, which is the most rapidly evolving one, is the cross-border data governance. Data is the lifeblood of the digital economy, but data does not flow freely across borders anymore. A great number of jurisdictions like India, Nigeria, Indonesia, Brazil, Russia, China have enacted, and they are enacting, data localization requirements that mandates that certain categories of data about their citizens or generated within their territory must be stored and processed locally. And for an MSME that has built its business on a cloud-based architecture that relies on the CRM, payment processor, or logistic platform hosted abroad, that is not a minor compliance footnote. It can require fundamental restructuring for the MSMEs. And to that and to the tension between the European Union data protection or the GDPR adequacy framework, which determines that which countries are deemed to offer sufficient data protection for European personal data to flow to them, and the rapidly evolving data protection law of emerging markets. And you have a compliance environment that is genuinely difficult, even for experienced legal practitioners to navigate, let alone a first-time international MSMEs, maybe looking to expand to Europe markets. And this is the minefield that I'm focusing on today. And now let me give you the map through it. It's not just enough that I have identified this minefield in these critical areas I'm focusing on today, but I want to give you what can be done in de-risking in the course of expansion, practical legal strategies. And this strategies, I want to be very deliberate here, because I'm not here to say give a list of things to worry about. I'm here to give you things to do. 4 concrete strategic framework that you can take from this session and apply directly to your expansion planning. And expand to your so because I'm also controlling the slide, so I've gone past that part of the slide. So the single most effective thing, so the first strategy I'll be touching on, one, is regulatory sequencing before market entry. And what do I mean by that for our MSMEs? The single most effective thing an MSME can do to reduce its cross-border regulatory exposure cost, nothing except time and attention. It must happen before commercial resources are committed to a new market. So as an MSMEs, before you even get into a new market, you must sit down to look at what are the regulatory exposure that I'm going to have in getting into this market. And I call it the 3-part pre-entry audit. The first component is a jurisdictional e-commerce compliance review. So as an MSME, do a compliance review. What are the registration, the disclosures, the consumer protection, and platform obligation in your target market? And do your current business practices satisfy them? It doesn't matter how long you've been operating in the current jurisdiction you are. So you have to have those pertinent questions when you're getting into a new market. The second component is an IP registration strategy. You must ask yourself as an MSME, have I secured trademark protection in the target jurisdiction? And if not, can you do so before your product or brand identity arrives in that market? Remember what I said earlier on, that IP does not just automatically follow the product to the new market. So the third component is a data flow map. You have to ask as an MSME, where does your customer data originate? Where is it being processed? Where is it stored? And does that architecture comply with the data governance requirements of both the source and destination jurisdiction? The sequencing matters enormously, and I want to be direct about one point in particular. IP registration must precede market presence. Like I mentioned, and I keep emphasizing it, not follow it. Once your brand is visible in a market, the window for opportunistic trademark squatting opens immediately. So I've seen businesses spend more on subsequent litigation to recover from their own brand name than the entire cost of proactive registration would have required. So businesses get into jurisdiction, they do not take IP registration as a priority, and then the cost of litigation now, because the IP, the trademark squatting bad actors have then gone ahead to register their brand before them, then they start spending so much on litigation. Meanwhile, they could have spent lesser, maybe sort of having a compliance plan or engaging an advisor or that could have helped them put the appropriate IP strategy in place. So the strategy 2 I want to touch on is leveraging multilateral framework as operational tools. In my experience over the years, in the course of my advisory work back in Geneva, Switzerland, I've had the opportunity to relate with most of the multilateral institutions and also led convenings on digital technology and trade with them, the United Nations Conference on Trade, the World Trade Organization, and the International Trade Center. And also I've been had the opportunity to work with them as a consultant and as an advisor. And one thing that I've realized is that these multilateral institutions, they have a lot of instruments. MSMEs tends to think that instruments like the WTO Joint Statement Initiative on e-commerce, also even at regional level, the AFTA Protocol on digital trade or the UNCTAD e-readiness, electronic commerce readiness assessment as policy instruments. MSMEs tends to think that these things that the government just negotiates and then the researchers just analyze them academically. That is not the case. These resources, they are underutilized genuinely, but they are underutilized by MSMEs. And this instrument, they offer valuable resources. These frameworks by multilateral institutions serves 3 practical functions for an internationally expanding MSMEs. First, they signal regulatory direction. When a jurisdiction is a signatory or active participant in a multilateral digital trade framework, its domestic regulatory trajectory becomes more predictable. So as an MSMEs, you can anticipate where compliance requirements are heading, not just where they currently stand. And second, they provide access points. Many of these frameworks established by these multilateral institutions and agencies and regional bodies, they have national focal points. They have trade facilitation committees. They have business liaison mechanism that MSMEs can engage with directly. And I hope to remember at the end of this presentation, I'm going to share the link to some of those resources that we, as MSMEs, everyone can start even taking advantage of. I'm going to share it in the Zoom chat. So that engagement is not just advocacy, it is intelligence gathering. Third is dispute contest. They can be invoked if a business believes a national measure is inconsistent with a commitment made under a trade agreement. The existence of that multilateral trade framework is the foundation on which a legal challenge can be structured. To give more understanding to that, I will explain further. So as an MSME, you are operating in a jurisdiction. One thing you need to pay your attention to is that this particular jurisdiction you are, this particular country you are, they are signatory to a multilateral framework, either with the World Trade Organization or a regional multilateral framework. So when dispute arises in the jurisdiction where you are operating, you must ask yourself, does this dispute or this matter, does it breach some of the agreements based on that international or multilateral framework? And that can serve as a foundation for you to institute your action in terms of that particular dispute, and for you to seek redress as an MSME in a jurisdiction. But when you do not even understand the full existence of this agreement or what is existing in the multilateral framework, then how does that MSME take advantage of such? So that's what I'm trying to explain here. So for those of you operating or for example, those who are looking to expand in Africa, there's so much going on about the African Continental Free Trade Agreement, wherever part of the world you are, across Europe, even countries in Europe and US, they're now designing African-specific focus strategies. So I want to draw your attention for those MSMEs who are looking to expand to African market, to the African digital trade architecture as a particular significant opportunity. This continental framework, when fully operationalized, will create a market of over 1.4 billion people, governed by a single overarching set of digital trade principles. And understanding that framework now, before it becomes fully operationalized, gives you a first mover regulatory advantage that will be very difficult for later entrants to replicate. And the third strategy that I will be touching on is building compliance architecture that scales. One of the most common and most expensive mistake I see growing MSME make is treating each new market as a bespoke compliance problem, essentially rebuilding their legal and regulatory infrastructure from the scratch each time they enter a new jurisdiction. That's not sustainable. That approach cannot scale, and it creates dangerous inconsistency across a business operational footprint. The most sustainable approach is to build a modular compliance-based line from the outset. So as an MSME, one design that will satisfy the highest common denominator across your target market. That is not as complicated as it sounds. Let me give you one concrete example. An MSME is targeting expansion across the European Union, or you're looking at expansion across the EU, you're looking at expansion also across country like Nigeria, across country like Kenya. It might not be like immediately you are looking to expand, but in your long-term view as an MSME, you are looking at these 3 different jurisdictions. Now, the point is that you face 3 distinct data protection regime in these 3 jurisdictions. The GDPR, you face that, the GDPR, Nigerian Data Protection Act, the Kenya that of the Kenya Data Protection Act, and then of course, that's the GDPR, the Nigeria Data Protection, and the Kenya. Now, these 3 instruments, one thing you must realize is that they have significant structural similarities. They all require lawful basis for processing. They have the same similarities in terms of data subject rights mechanisms. They have similarities in terms of breach notification protocols. They also have similarities in terms of cross-border transfer safeguard. It may even interest you to know some of these other acts were modeled after the EU GDPR. Now, privacy by design architecture, which an MSME can build to satisfy the demanding of this theory, is the GDPR. And what will this do? So if you build a compliance and a privacy design architecture as an MSME for your business, even as you are seeking to futuristically expand across these 3 different jurisdictions, if you build it and it's in compliance with the GDPR of the EU, what that means is that it will relatively adapt and satisfy the criteria of these 2 other jurisdictions you are looking at because of this area of similarities. And what you have done is that you have built once and you have deployed 3 times. Rather than building 3 times at 3 times different costs, rather than going to the EU, you have one separate sort of set of strategy, legal, in terms of navigating the regulatory landscape, that costs a lot. And then you move into the Nigerian market, and then you start a new one, and then you move into the Kenyan market. That's going to cost a lot for an MSME. So the strategy is to have this kind of privacy by design or sort for your data protection, such that it satisfies the most demanding, and then you can also adapt it to the other jurisdiction that you are looking to expand to, especially because of that similarity that they share. And then the fourth strategy that I will be talking about is the strategic IP portfolio construction. As an MSME, treat your intellectual property not just as a legal formality to be attended to when a problem arises, but as a market entry asset to be constructed deliberately before you enter the new market. Two instruments particularly offers cost-effective pathways for multi-jurisdictional IP protection that many MSMEs are not fully utilizing. Now, I had the opportunity to also consult with the and also some sort of academic engagement with the World Intellectual Property Organization in Geneva, in Switzerland. Now, that institution, as a multilateral institution, has what we call, I've been able to put together what we call the Madrid Protocol. This is an institution that has about 193 member states. So the chances that most of the jurisdictions that you are looking to expand to are members of that institution. Now, membership of the institution does not also mean that all of the members have acceded or they've sort of signed all of these protocols. So where the area of your work as an MSME is to look at the country where I'm looking to expand to. Are they a member of this particular protocol? And I'll give the example of the Madrid Protocol. Now, the Madrid Protocol allows you to file a single international trademark as an MSME application that designates multiple members countries simultaneously at significantly lower cost than filing individually in each of these jurisdictions. So what it means is that if you file with the Madrid Protocol, it will give you coverage to over 100 of countries. So you don't have to go to those countries, or each of the time you are looking to expand there to sort of say you want to start doing a new registration there. The Patent Cooperation Treaty provides an equivalent mechanism for patent protection also across PCT member states. So, and for those who are looking to expand across the African market, I want to also highlight the ARIPO to you. The ARIPO is the African Regional Intellectual Property Organization, covering the English-speaking African countries. And then there is the OAPI, which covers the Francophone African countries. So if you're looking to expand to African markets and you're looking to add the best framework for your IP protection, your trademark, or everything that's got to do with your intellectual property, both institutions in Africa have regional registration pathways that can be utilized, and they offer substantial cost advantage over jurisdiction by jurisdiction filing, just as also with the taking advantage of the PCT and the Madrid Protocol, and also other conventions that these international institutions have been able to put together. So I will be closing with this. What is the central theme of this convening, of this convergence? It says the agile, intelligent, and sustainable trader. So let me bring this back to this. And I said, because I do not think that this coining of the agile, intelligent, and sustainable trader, I do not think they are just abstract institutional values for an MSME. I think they are precise description of what the next generation of successful international operating MSMEs will actually look like. And the legal and regulatory strategy is central to all of these three. Agility in the regulatory context means building compliance framework that are designed to adapt. The digital regulatory environment is not static. It is in a state of continuous evolution driven by technological change, geopolitical realignment, and growing recognition by governments worldwide that the digital economy requires active governance. So the MSMEs that will thrive in that environment are not the ones that solve today's compliance problem and move on. They are the ones who have built adaptive system, compliance architecture, monitoring mechanism, and legal relationships that can respond to regulatory change without requiring them to rebuild from scratch every time there is a change. Intelligence means using the multilateral architecture proactively. I've highlighted some of them today. It means knowing not just what the rules are today, but where they are going. It means engaging with trade facilitation mechanism that exists precisely to give business access to that intelligence. And it means investing in the legal and policy literacy within your organization, within your institution, or through advisors that convert regulatory complexity from a threat into a source of competitive advantage. And for sustainability, it means understanding that compliance is not a sunk cost. It's a long-term investment in the integrity and resilience of your business. The MSMEs that cut corners on regulatory compliance to reduce short-term costs are the ones that face market exclusion, platform delisting, IP loss, or data breach liability at the worst possible moments in their growth trajectory. So the business that invest early in building sound legal foundation are the ones that can scale continuously, enter new markets efficiently, and attract institutional partners and capital that accelerate growth. The MSME that will dominate the next decade of global digital commerce will not necessarily be the best resourced. They will be the best informed, the best prepared, the most strategically deliberate in how they approach the regulatory environment that they operate in. And what I hope you leave this session with is the beginning of that advantage. So thank you for your attention, and then I look forward to your questions.
Thank you so much. It was so informative. I love that you call them the agile, intelligent, and sustainable trader. But more than that, what I've been interested with is how you talk of the minefield that e-commerce, intellectual property rights, and cross-border data governance is. Because that actually, I mean, I've never thought of it as a minefield, but I think what you put it into is actually so true. It is a real minefield. And the sooner we realize what a minefield it is, the easier it's going to be to navigate all these processes.